Hello everybody, good afternoon and welcome to a Veazy Live Q&A, exclusive Veazy User Live Q&A with myself, Martin Salvo, Principal Immigration Lawyer at Salvo Migration and founder, creator of Veazy. You guys obviously all know all those things, but good to introduce myself anyway. And for those that haven't, I suppose, had a live stream with me in the past, welcome. We used to do this quite a lot in the past, but we scaled it back and kind of focused on client work and getting Veazy ready to be available to the general public, about 12 months ago. So anyway, let's dive into the question. So again, from another anonymous user, we have a lease together in our names, but we also have other people who live with us. We rent the second room of an apartment. Is that a problem? No, it's not a problem, but we'll talk about that in a bit more detail in a minute. I'll just keep reading the question. Should we ask them to pay in another account? Maybe. Question. We have separate accounts and we use the joint account to pay for rent, bills, groceries, but we have just pay as we go. Should we just start transferring a certain amount every week to make it look like we are actually saving together? So look, I think this question touches on a couple of areas. The first is how to optimize your relationship evidence when you're cohabitating with other people. So if you're a couple that live with others, how do you put across that evidence the best way to strengthen your claims of being in a de facto or married relationship, even though you're living with others? That might be the first half of this question. The second half of this question is, I believe, you're asking how to use your funds in order to pay for your half of the rent. So your funds as a couple, how do you pay for your rent in the best way possible, or the way that allows you to evidence your relationship the best? That's my interpretation of your question. I'll try to answer in that way. If I've misunderstood the question, please feel free to ask again. So to work through the question, you live with other people. Is that a problem? No, that's not a problem. Couples don't need to live solely by themselves in order to prove they're living together like a de facto or married couple. It's not about having your own house per se. It's about being able to prove that firstly you are cohabitating, and secondly that you are cohabitating and maintaining a home together. Now your home in these types of scenarios when you live with other people is shared with others, and that's fine, but you still want to explain, particularly in your relationship statements, how you and your partner share the responsibilities of maintaining your half of that apartment or your room in that apartment. So you talk about, for all intents and purposes, your room is your home, and that you share the cooking responsibilities, you share the cleaning responsibilities. He does this, she does that, and you talk about how you live together as a couple, even though your living space is small in a sense. It's just a room in this instance, and obviously you share the communal areas with the other couple. Again, that's fine, but you just want to talk about how, despite the fact you live with people, you're still maintaining a home as a couple, and explain that in your statements. Should we ask them to pay in another account? Maybe. I'm not clear on exactly what you mean there, but kind of to address the more important topic here is what I would recommend when it comes to optimizing your financial aspect to pay for your rent. So even though you're living with others, how do you optimize your financial setup, your structure, to pay for your rent as a couple to maximize your claims of being in a de facto married relationship? Now, what I'll do is I'll jump to my trusty whiteboard, and I will draw this, okay? So in this scenario, you have a home, okay? And we're saying that it's, let's say, split in two. You have you guys as the couple that live in that half of the room or of the apartment or the house. You have your room, and then maybe there's other people that live in the other area, the other rooms, other people live in them. So that's the scenario, right? Now, I'm not worried about how they pay for their rent. That's not relevant to your claims of being in a relationship and trying to prove it to the standard of meeting a partner visa requirement. I'm more concerned about you guys having your bank account set up properly and paying your half of the rent appropriately and being able to evidence it in the best way. And that would typically be where, let's say you're both working, okay? And there's a couple of options here, but ideally, if you would ask me what would be my preferred setup, it would be that you're both getting paid your income into your joint account. Okay, so your joint account, and then you're using this joint account to pay for your half of the rent. It's not what you've arranged with your landlord, though, may dictate how your current rental payments are made. I'm not sure if you transfer funds to these guys and then they pay the rent. I mean, you don't want to make it too messy. Ultimately, all the real estate agent's worried about is that they get, their $500 to whatever it is, $1,000 a week from this house to pay for their rent. So you should be well within your rights to just transfer your portion directly to the real estate agent from your joint account. I think where things start to get a little bit messy in this scenario is when you start transferring funds to these guys and they're the ones paying the rent from their account. Ultimately, I want you guys to be paying the rent from your joint account, whether that's the full amount after they've transferred to you and then you pay the rent, or you just pay your half directly to the real estate agent. That would be how I would recommend you organize your rental payments in this scenario. But the important thing is that it's coming out from your joint account, and you're able to show that these expenses are for your rent. So you're providing your lease agreement. It shows you're both there on the lease. Yes, it's with other people, but the point is you can still show you're both there. You have your joint bank account, which shows that you're paying your rental payments every week or every month or every fortnight, whatever it is you have it set up to be. And that's how you prove that a couple are living there. Joint lease, bills, mail, and rental payments from their joint account, preferably. Then what I often recommend is, don't just use this account just for rent. I mean, use it for anything that relates to your relationship expenses, groceries, dinners, trips, your portion of the water bill, your portion of the gas bill, your portion of the electricity bill. It's about accumulating transactional history in your joint account that relates to your relationship and living expenses primarily. That's the important component here. Then, to further maximize how you've optimized your joint financial structure, is we would recommend having multiple sub-savings accounts. So show that not only are you as a couple pooling your finances to pay for your rent together, but you're also pulling your finances to save for your futures together. Now, I suppose a little hack or recommendation that I can give you is, go to your online banking portal, rename your bank accounts. Call one home deposit, call one wedding, call one baby, and demonstrate to the department visually that you are pooling your finances for what you hope to be large milestones in your relationship in future. That's how you show the commitment to the relationship, is what you're planning to do in the relationship. And you should be talking about all these things in your relationship statements anyway. But if you can prove what you're saying in the statements by showing you're putting a bit of money aside for those things, it's just going to be a better evidenced financial aspect in this instance. So I hope that answers your question. I'm sorry if I've misunderstood. If I have, please feel free to ask again and I'll work through it. Hi Martin, if the applicant has health checks overseas through eMedical within the last 6 months for a 600, and they are now asking for them again for the 820, do we need to do them again? It depends on the medicals that were completed. I can't be sure if the medicals that were asked for the 600 will be all the medicals that they will require for the 820. They can be different depending on the length of stay that's been requested. But what I would recommend you do is ensure that you've provided the department the HAP ID, so the HAP ID for the last medicals that were completed, and ultimately it'll be for them to determine whether or not they need new ones or not. The length of time is fine, so I'm not concerned about 6 months. Typically they're valid for 12, so it's not that they've expired per se, it's that they may not have covered all the medical tests that are required. So worst case, they'll ask you, the applicant, to do them all again. Best case, they may say, well, you've already done your chest x-ray, so you don't need to do that again. You just need to do this medical and this medical, and maybe it'll just reduce the cost for you a little bit without needing to double up on repeating tests that can be reused. So they're not single-use tests, in other words. They can be used for other applications. Again, so the time frame's not an issue. It's more whether or not the tests themselves cover all the tests that will be required for the partner visa, which can be slightly different. Hi Martin, for an 820, language ability evidence, should we still just leave it at this stage? Yes. And this was something I was going to cover and talk about if it wasn't asked anyway, but thank you for prompting me. The changes haven't happened, okay? So meaning, if you're using Veazy to prepare your application, presumably you are, that's why you're in here, and you haven't submitted yet, as things stand at the moment, the changes to the sponsorship framework and also the English language requirement haven't come in. Now, what's causing a little bit of panic and confusion in the industry is that if you have a look at the IMI checklist, so after people submit their partner visas, the IMI checklist is available for you to start uploading your documentation, okay? There, you will see that the government have, sneakily added a category there for English language proof. And that's causing questions. People are saying, "Man, do I need to attach English language test results?" It's saying it's recommended, but I can't find anywhere confirmation that the changes have actually come in. So at this stage, that's just them, I suppose, getting the back end system ready for when the changes come, so that there's an area there for people to start uploading English evidence language to their applications. So they always have to do that first, because they can't turn it on and then people are submitting and then they don't know where to attach their English language test because there's no appropriate category in the IMI checklist. So it makes sense for them to turn it on first in the back end. So that's why it's there. And like I said, that's kind of flying on to people being concerned and having questions. But point being, and to answer your question more directly, you don't need to provide English language test results. There's no English language requirement for visa applicants or sponsors at this stage. So if you've already submitted, you don't need to worry about it. If you are yet to submit, if the changes come in, depending what the changes ultimately end up being, because we're still not 100% sure what they're going to be completely, we'll only know once they come into effect and they've finalized everything. But based on what we understand, if and when they do come in, there's going to be English language requirements for applicants and permanent resident sponsors. What we understand though is that it's not going to be needed when you apply for the initial visa. It's only going to be required when you have to prove the second stage of the application, which is your permanent application. So that's many years down the track if you kind of look at timeframes. So either way, nothing really any of you in this group are likely to be caught out by. But if we wake up tomorrow and the changes have come in, then the conversation may change depending on what the changes are, and if it's warranted, I'll do another live stream into this group and we'll talk about it and break it down. Another Facebook user. We just opened a joint account a month ago and I live in his house, so we do not have many bills together. Both of us have our own bank account and do not contribute the same amount into the joint account. What should we do to strengthen our financial aspects? So I think a starting point is, I suppose, to kind of revisit what I've mentioned here. And really, guys, this is, if anyone who's ever had a call with me, or I'm not sure if you've uploaded this onto the YouTube channel, because I try to keep some stuff separate, private, and for exclusive to Veazy users and whatnot. But this is what I would call our optimized financial structure, and it is what we recommend to any couple that are living together in Australia. Now, if you're living apart from your partner, or if you're living overseas, this structure or setup may not be possible due to obviously various restrictions. If you're living separately, often you can't open up joint accounts, and so even if you're living overseas together, certain countries don't allow Australians to open up accounts with visa applicants. So that may not be possible for certain couples, and that doesn't mean they're going to have problems. I'm just kind of drawing and outlining what our optimized financial structure looks like. If you want to really strengthen your financial aspect as best you can, and you're here in Australia living with your partner, this is what we recommend doing. Have your joint account, use it for your living expenses, and then show that you're saving for your futures together. That's a very foolproof way to start differentiating your financial aspect from just being boyfriend, girlfriend, boyfriend, boyfriend, girlfriend, girlfriend. You're not just dating, you're living together, you're pooling your money to live together, and you think you're going to live together forever. So that's why you're saving for your lives together, and that's why we recommend those sub-savings accounts. So in terms of what I recommend doing, I recommend doing this, for as long as you can prior to submitting the visa application. How long you do that for really depends on when you're looking to submit the application. Now, when do we submit a partner visa application is a super common question, and really it's dependent on, deadlines. For example, if you are here in Australia and your visa is expiring, and there's it makes sense to apply for the partner visa. You're not looking to extend your stay on a student visa or on a visitor visa. You just want to get the partner visa in before your current visa expires. Well, then obviously you need to do this for as long as you can prior to the visa expiry and apply for the partner visa before your visa expires. However, if you're here on a temporary visa that, let's say, is valid for a little while, 6 months, 12 months or more, then there's less certainty because you have time. You're not pressed by that visa deadline per se. And this is often a bit of a conundrum. People that are here on a temporary visa that have lots of time often find it more difficult to know when to submit their partner visa because they're not pressed by a visa deadline. They're more, they submit their partner visa more around ultimately when they have evidence their relationship the best. They can't get any more relationship documentation. They've gone through the Veazy checklist. They've watched all the videos. They've had their coaching calls. They just can't get anything else from their relationship. They've evidenced everything as much as they can. And then really at that point, it's probably appropriate to apply for the partner visa, obviously depending on the relationship facts of the couple. So how long those couples should pool their finances for depends. If they're married, there's no length of time requirement, because married couples don't have a minimum relationship length requirement. If they're de facto and not in a civil union, then ideally, we would want this for around 12 months because you're trying to meet the 12-month rule. So if you're in an unmarried relationship and you haven't registered your relationship as a civil union, then keep in mind that the 12-month rule will apply to your application. If you don't know what the 12-month rule is, please go to our YouTube channel, have a look at the video that I have there where I talk about the 12-month rule. But basically, if you don't register as a civil union and if you're not married and you apply for the partner visa, you're in a de facto relationship, they're going to want to see you were de facto 12 months ago. And really, kind of two very core components of proving you're de facto are living together and paying for your living expenses together. If I was to absolutely condense and simplify what it means to be de facto. How long you do it for depends. It depends on deadlines primarily. If there's no deadline, it depends what your relationship facts are, and it's about finding a balance about when you think you've evidenced your relationship as best you can and then submit the application. So that would be my answer to that question. Mr. V. Hi man, for an 820, residential evidence of couple living together evidence, only been here 1 week. What to do? What couples should do depends really on their entire relationship context. Obviously, I know your relationship well. We've had calls. So I can probably advise you a bit more specifically. But, when it comes to previously, where people were coming in on travel exemptions, which I believe is your case, bringing in your partner on a travel exemption and visitor visa, right? So when the borders were closed, couples were applying for travel exemptions and visitor visas for their Australian partners to get them here quickly. And as part of that process, they had to evidence their relationship, right? So you had to prove your relationship to get the travel exemption, and we also recommended doing that for the visitor visa. So in some sense, you've already collated most of your relationship documentation anyway, because you needed it for the travel exemption and the visitor visa. So when we were handling cases in that scenario, we would say to people, okay, we'll submit the travel exemption, we'll submit the visitor visa, we're going to treat them like your partner visa. So go to Veazy, get everything we say there, and obviously we'll look through everything, we'll complete it on our end, and we'll submit everything to the government. So like 90% of the partner visa is done in a sense, in terms of the documentation. And then we would say, okay, once the travel exemption and the visitor visa granted and you're here, it's just about topping up, just bridging that gap with your Australian-based evidence. So show that you're now living together here, show that you've opened up a joint account here, and maybe try to get the visa applicant and sponsor on a bill or two, or an account or two linked to that address. And that's really all that should be required, because if you were already granted travel exemptions and visitor visas on the basis of your relationship, there really shouldn't be much more they require now for the partner visa, because they've already kind of pre-accepted you in the last applications. Yes, it's different. Yes, now they're going to assess your relationship, but I'm very confident on that advice, because that's how we approach our client cases, and it makes sense. There's no need for you to worry about living together for 2 to 3 months and accumulating more evidence together, because you probably have already enough based on your history. But I suppose the approach is to top up the the last lot of documentation, you already collated with your Australian evidence, and don't stress about it too much, but try to give them some things. Focus on living together evidence and financial pooling here. Look at superannuation beneficiary for your policy here, and if you really want to, look at online wills. They're Australian legally binding documents, and they're kind of the big ones. Okay. Hi Martin, how important is the overseas marriage certificate? I hate social aspect for A20 application. I hate marriage certificate for the social aspect. Okay, I think I've deciphered the question. I'm currently on a visitor visa. My husband don't have an Australian citizen or PR to do the Form 888. I'll just reread that, and I'll try my best to answer this. How important is the overseas marriage certificate social aspect for the A20 application? So any marriage certificate is important. So whether a couple have married overseas or married here, depending on the circumstances of that marriage overseas, but more often than not, it's going to be legally recognized here, reciprocally recognized. So a marriage certificate means that a couple are applying for an onshore partner visa as a married couple. So couples don't need to marry here to apply for the 820 as a married couple. You can marry overseas. Happens all the time. So is it important? Yes, it's important, but only in the context where a couple has married overseas. So if you haven't married overseas, then it's not important because it's not relevant to your facts. But if you guys have married overseas, then yes, I would certainly recommend including that as part of your evidence. I'm currently on a visitor visa. My husband doesn't have an Australian citizen or PR to do the Form 888. Yeah, so it's not legally mandatory that you have witnesses that are Australian citizens or permanent residents. There is a section on the form where it's going to ask you for details of witnesses. Now, you want to be providing preferably the details of an Australian citizen or permanent resident on the form, because that's what it asks for specifically. But in the absence of that, if you don't have any Australian citizens or permanent residents to be your witnesses, then you have to give them the details of other people that are not Australian citizens or permanent residents. So that would be my first suggestion. Secondly, if you don't have any Australian citizens or permanent residents that can provide Form 888s, which is different to the visa application form that I was just talking about. The visa application form, there is a section that asks you to list 2 witnesses. So that's the first kind of area that this pops up. The next is the actual Form 888s. It's not legally mandatory that you have Form 888s. What is mandatory is that socially, those that are closest to the couple, so you and your partner, know about your relationship and can attest in writing that they believe that you are in, I believe in this case, a married relationship. So, supporting statements from people closest to you is important to the social aspect. Doesn't mean they must be from Australian citizens or permanent residents, but they will typically hold more weight. They can be deemed more genuine or more authentic in the eyes of the Australian government because they're provided by Australian citizens and permanent residents. Whereas maybe statements written overseas, there's a less certainty about the origins of that statement, who wrote that statement, so you kind of have to approach this logically in a way. So point being, if you as a couple, when you're providing your supporting documentation, don't have any supporting statements from permanent residents or citizens, I would definitely be recommending providing as many supporting statements as you can from others that are not Australian citizens or permanent residents. People that are here, so people that are in Australia, they can still complete Form 888s. So they don't have to be Australian citizens or permanent residents. Okay, so if you have friends that are on temporary visas, a lot of students or working holiday visas or visitor visa holders that are here, get them to write their Form 888s and that's fine. They just have to sign in the presence of someone that's authorized to witness their signature. Who can witness signatures in a Form 888, it says on the first page of that form. So look at that first page. It says who your friends have to sign in front of. Lawyer, doctor, nurse, pharmacist, teacher, a whole list of occupations, okay? And you also need to provide a certified copy of that person's ID. Okay, so passport, driver's license needs to have their photo ID and their full name, and a certified copy. So you must have the certified copy of their ID and must, preferably on a Form 888. Friends and family overseas, they don't have to write Form 888s. They just need to write supporting statements. Now, often what I recommend is if we're talking about people overseas, is for them to write their statement on whatever the official statutory declaration form is in that country. So if someone's in a particular country, and let's say India, and in India there's a government form, or there's official forms that people can use to make declarations. Now, if they're going to use that form, that's fine. What you want though is that, let's say it's your mum in India. She's writing her supporting statement for your partner visa application. She writes her supporting statement in the official form in India. You just want her to answer the same questions that you see on the Form 888. The Form 888 asks specific questions of your mum. It says, how do you know the applicant? Well, she's my daughter. How do you know the sponsor? She is my daughter's husband. I've known him for 2 years. He came and visited last year, or I have Zoom calls and Skype calls and Messenger calls with them since this day. I've known them for this amount of time. Why do you think the relationship is genuine and continuing? Well, I've seen my daughter's relationship with her husband develop over the years, and I've never seen her so happy, and we love to have them visit, and so she can answer the same questions that you see on the Form 888 in her statement that's written on the official form in India. And then she just writes it or types it, and she gets that, she signs that again in front of whoever it is that's authorized to witness that form in that country. Okay, so just think about it. A little bit. It's more flexible when we're talking about statements from people. It doesn't have to be Form 888s. The Australian government, just want to read statements from people that know about your relationship with the applicant and sponsor, and preferably they want them to be Australian citizens and permanent residents, and preferably they want them to use a Form 888s because it asks certain questions of that person. But people overseas, don't often know what a Form 888 is. They don't want to touch that. They just want to write their statements on whatever the form is overseas for them to make that official declaration. That's fine. Doesn't need to be in English. So if they're writing their statements overseas in their native language, that's fine. You just need to get it translated. Okay, if you're applying for an onshore partner visa, you must translate anything that isn't in English, particularly supporting statements from friends and family overseas. Okay, so I hope that answers that question. Oh, I got one more. Trin's back. Trin, hi man, thank you very much for answering my question before. Is the more Form 888 the better? I think I can get around 4 forms, but do not know if it's enough. Also, so I'll answer that bit. Yes, the more the better, but you don't need to go too crazy in trying to get too many. And I suppose the best way I can answer this is that our client applications, we will on average have anywhere from, I'm going to say 6 to 10 is the average. Okay, now something that I kind of a metaphor that I use to try to teach or explain what you're trying to get when it comes to Form 888s is, think of it like a pyramid. Let's use my whiteboard. I think is a great drawing opportunity. So, okay, you have the whiteboard. I'm sorry guys if you can't see the full triangle. And let's split that in half. Okay, you have the applicant half, and you have the sponsors half. So what that means is that you want supporting statements from people that know the applicant and people that know the sponsor. So the applicant's side and the sponsor's side. I'm going to say that there is, let's say, a strength multiplier. So supporting statements that are going to hold the most amount of weight will be those written by Australian citizens and permanent residents, which is something I was touching on before. So statements written by citizens and permanent residents are more verifiable and will hold more weight in the eyes of a case officer or the department. There's no official multiplier or strength multiplier. I'm just trying to use this as a teaching exercise, okay? Secondly, now we kind of split this into groups of people. So at the top of the pyramid, what's going to hold the most amount of weight are people that know the couple the best. And typically, kind of statistically, that means immediate family members. So immediate family. So you have parents, siblings. So, if you have one parent, one sibling, that's 2. Then we have, let's say, extended family. So cousins, aunties, uncles, grandparents. So if you have one cousin, one auntie, that's another 2. And then we have, let's say work colleagues and friends. Work colleagues and friends. So you have, one work colleague and one friend. So you have 2, 2, 2. You're already at 6, kind of without really trying. keeping in mind that ultimately what you want is you want to kind of focus on these. But generally speaking, the visa applicant, the majority of their supporting statements, particularly let's say immediate family members that are probably back home, are not Australian citizens or permanent residents. So, when you look at this realistically, more often the Australian citizen and permanent resident statements will be written by those that know the sponsor, and the majority of the non-citizens or permanent residents will typically come from the visa applicant. So that's kind of how I would like you to approach it. Don't worry too much about a number. Just use the guide that I gave you as an estimate, 6 to 10. But when you approach it in this way, you can see how you kind of get to that 6 to 10 average pretty easily, because you're just trying to hit all these groups and you're focusing on both sides. That's what matters. And ultimately, what matters the most is what they say. What they say in their Form 888s is what matters the most. And what you want them to say is that they believe that you are in a de facto or married relationship. That's what matters. And the words they choose to say that in. So it's not about quantity, it's about quality. And the way that you enhance the quality of the supporting statements from your friends and family is that you get them from people that know the couple the best from both sides. And if you can, you focus on statements from Australian citizens and permanent residents, and the government have provided you a template to give them, which is the Form 888. So that was the first half of that question. Also, can a CA accountant certify the form? Trun, I believe so. On the first page of the Form 888, it'll say who can witness signatures on a Form 888. I would be surprised if a CA isn't there, but you'll just have to check. I can't say off the top of my head. But assuming it is there, then yeah, by all means, your boss can definitely certify forms. But he needs to witness signatures. So your friend or whoever it is needs to go to your boss and needs to sign in front of them in order for him to witness their signatures on the Form 888.